Newsroom Africa.
Newsroom Africa. Acknowledged, yes.
MD. Sorry.
You are very eager. Let me hear you first. Okay, you are?
MDN TV.
MD. MDN TV, yes.
Daily Maverick.
Daily Maverick. Yes. Okay. Is that News 24?
No, that's
Different. Okay. Netwerk 24, yes. Sure.
Cubit Media.
Cupid.
Cubit. Q-U-B-I-T.
QU.
B-I-T. Media.
Cubit Media, yes.
Gallo Images.
Gallo.
Gallo,
Yes.
yes.
Mail and Guardian.
Yes.
Oh. Yes. Everyone. Okay, that's it then. Thank you. All right, Advocate Otis, I do have a copy printed out of your head, so if you are ready to proceed, I'm ready. Yes. No. Advocate Otis, I just want to make sure, is there a microphone in front of you? If you can just... No. Oh, if you can just... Okay. Thank you. I just want to establish one aspect. Although we filed the heads, are you not of the view that at least our record should reflect what is contained? Because if we get to transcription, this is obviously not going to form part of the formal record. So if it takes time, it's fine, but it won't be on the record if it's not.
Your Worship, it was my intention to deal with the heads of myself and my lawyer. It would make no sense for me to stand there, read my heads, and he reads his heads.
Oh.
So I'm going to anticipate his heads and then give him a chance to then deal with my submissions.
Oh, okay. I now follow you.
In fact, Your Worship, my intention was to go as to what happened on the last occasion, what the arrangements were, what's then transpired, followed by the heads, a few submissions, and conclusions. I won't be long, Your Worship. I do believe that we can even finish this morning on the submissions and all.
Not a problem. Thank you.
Your Worship will by now have a copy of the transcript of the previous occasion. So just to put everything into context, Ms. Thompson testified, it's quite clear, is that I asked the court to inquire from the state, this is page 172, whether they had in fact closed their case. And they said the state has not formally closed their case and we're waiting to hear. Thereafter, they formally closed their case, Your Worship, and said that they're not calling any evidence in aggravation of sentence. That's from page 172. What then happened, Your Worship, was there was an agreement that we file our heads of argument by the end of March. On the 31st of March, Your Worship, 2 weeks to go through the heads of argument and be ready for today. And we now know that we filed on the 31st of March, Your Worship, that absent this case that intended to include in the heads of argument. Thereafter, the state only filed on the 1st of April, and I was told that they wanted to see our heads before. Thereafter, Your Worship, the state filed supplementary heads last week, Thursday. Your Worship, of this provision. So that would set the factual background to where we are at this stage, Your Worship. Now, turning to the heads, Your Worship, if I may take Your Worship through our heads just by way of introduction, and I don't intend to stand before Your Worship and read every year. But what we did, Your Worship, and my own friend adopted a similar approach in his introduction, is we described by way of introduction the offences of which the accused has been found guilty. There are 5 words that may be summarized as being unlawful possession of a firearm, unlawful possession of ammunition, the unlawful discharge of a firearm in a caught-up area, the unlawful failure to take reasonable precautions to avoid danger to personal property, and finally reckless endangerment to personal property. So those were the 5 charges, Your Worship, on which the accused was found guilty. And then what we highlighted and emphasized throughout the heads, Your Worship, is that all 5 charges related to a single incident, being the 5th Economic Freedom Party celebration that occurred on 28 July 2018 at the CIC Stadium in Tanzania within the jurisdiction of this Honourable Court. And what we say, Your Worship, and it's highlighted further throughout the heads of argument, is that all 5 charges were committed in a very short time span of less than 1 minute. And we then also, and we had agreed on this previously, Your Worship, that there was no indication that any minimum sentence legislation applied. In this case, because the accused had not been warned accordingly, and I do believe that there is common cause on that, so there's no need to go into the case of dealing with that particular aspect. And then we went through the report of Ms. Jessie Thompson, Your Worship, who was called to give evidence in mitigation of sentence, and she highlighted his personal circumstances, and particularly that he was a 45-year-old first offender, having never been convicted of any offence. And we say equally significant with respect to the fact that despite the lapse of 8 years since the commission of these offences, the accused has not been convicted of any other offences. So he's 45 at the moment, he was 37 at the time of the commission of the offences, and he led a blameless life. In the interim, there have been no intervening incidents or anything that would aggravate the circumstances of this honourable. We then summarised Ms. Thompson's report, Your Worship, and who she had interviewed and what information she's utilised, and that she sought to follow the Zim triad and all the relevant considerations. And she had regard to his personal circumstances. And we say even that in relation to this in paragraph 13 of the head, Your Worship, the principle of remorse is found that the accused continues to assert his innocence. Nevertheless, she was of the view that the accused regrets the incident and the consequent result that people may perceive it as encouragement to handle firearms recklessly, which was not his intent. In that regard, Your Worship will know, and we received, as I recorded, Your Worship, the transcript of Your Worship, this also in questions of clarification, and made it clear, Your Worship, on the record, and I can give the reference to Your Worship, that people are entitled to plead not guilty, that is their right, Your Worship, to put that to Ms. Thompson as a clarifying question, and she had agreed in that regard, Your Worship, that would be the case that one may be entitled to plead not guilty. That's at page 162 of the record, Your Worship clarifies that. So that aspect was fully dealt with and canvassed by Ms. Thompson, and she said that she was of the view that the accused regrets the incident and the consequent result that people may perceive it as encouragement to handle firearms recklessly, which was not his intent. We then explained how she dealt detailed in criminal behaviour and current offences, and that there were no cases pending against him. And she had regard to the prevailing circumstances at the time of the commission of the current offences and the seriousness. And in paragraph 15, we say in regard to the seriousness of the offences, she had submitted that it was necessary to evaluate the level of actual and potential harm caused by the acts in question, as well as the degree of culpability attributable to the offender. And then in 16, we set out to worship what she highlighted, and that was that he had obtained the firearm from an individual most likely affiliated with tactical security services, who was authorized to possess and manage a licensed firearm, He had done so solely for the purpose of discharging celebrating shots at the event. He had not acquired the firearm illegally for a prolonged period or with any intent to facilitate further criminal activity. He returned the firearm to its lawful custodian promptly after firing the celebrating shots, and he possessed the firearm and ammunition only for the period during which the celebrating shots had been fired, which, while not precisely timed, he estimated to have lasted less than 1 minute. So he highlighted those aspects which she had brought to the court, which the court was aware of. And we also say that she highlighted the purpose and the constitutional rights to life, body integrity, that is the purpose of the Firearms Control Act 60 of 2000. And in that regard, she said as follows, it's in 17.1, there's no evidence that the accused intended to cause harm. Secondly, that by neglecting to take such precautions, it is said that the accused acted recklessly. Thirdly, that the discharge of firearms in the public settings conveys an inappropriate message, particularly from a prominent leader, that it was noted that the accused regrets the incident, and that she said there was no evidence indicating any harm to personal damage to any property. We say the firing of celebrating shots had been deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. However, available information did not suggest that the planning of this activity was undertaken with the intention to commit an offence, endanger lives, or cause damage to property. We also say, Your Worship, and I think Your Worship, the references in Ms. Thompson's report and in the record, that it's unusual, and this is illustrated, Your Worship, by the fact that the firearm in question was actually returned to technical security services before judgment was even delivered in this trial. Your Worship will find that at paragraph 50.4 of Ms. Thompson's report, and at page 35 of the record where she refers to it in her oral testimony, and that was never disputed. We say that's a distinguishing feature, because all the cases that my learned friend refers to, and I'm jumping the gun to a certain extent, have firearms where the markings or distinctive features are obliterated or modified, that are intended to commit more serious or heinous crimes, and therefore there was more to hand in relation to the firearms. The one possible exception which I will deal with is the Pistorius matter. It was a friend of his firearm that he shot under the table. He wasn't licensed to possess it. The argument was the friend had handed it to him, saying there's one up in the chamber, it's a concoct. He denied that, but it was never put to those witnesses when they testified. Ms. Thompson also said this when she testified at page 35, that no individual was convicted of supplying or transferring the firearm to the accused, and the rifle that was shown in court was returned to tactical security services before judgment was delivered in this trial. So that's a distinguishing feature that would bring us in line, Your Worship, with the Pistorius type of matter, and that we say that the court ought to have regard to. Now, paragraph 20, Your Worship, that she said that she dealt with these individual objectives and with regard to numerous judgments, but did not trace any judgment dealing with accused persons who have been charged with discharging a firearm for celebratory purposes. Now, Your Worship will be aware now that's a big aspect that's covered to a large extent in our heads of argument, but and the state in their heads of argument say it ought to be an aggravating factor. But I think they're missing the point, and let me make it clear, Your Worship. They say the fact that one cannot find any cases dealing with it doesn't have any significance. But the point is, Your Worship, if one has regard, and I'll even ask the court to take judicial cognizance of this, when we watch the funerals of prominent leaders and other people in the community, very often there's firearm shooting with those people who aren't charged. And there's no case that we were able as a team, a large team, to trace that we deal with such instances. And that's the point that we're trying to make, that it's very unlikely, and it hasn't happened in the past, that people were charged with those offences, even though we see them on TV on a regular basis. Then Ms. Thompson recommended, as do we, that all 5 charges arose from a single incident and the accused had not loaded the firearm, the charges should thus be considered collectively for sentencing purposes. Now it's taken together. She then proposed a mandatory fine, that the accused be restricted from obtaining a firearm license for a particular period, and a mandatory donation. In the heads, we worship in paragraph 22, we deal with the cross-examination, and that was put to her, and it's now on the strength of the listed decision from the judgment, that to impose a mandatory fine would be conveyed unless the accused who pays way out of jail. But her response to that was that jail is not necessarily the correct way to go. So what we say, Your Worship, is that even though the states take exception to the possible imposition of a mandatory fine, we say that this is still constitutionally recognized as a possible offence and ought to be taken into account. Then she was re-examined, Your Worship, and then the court asked clarifying questions, and that's where Your Worship asked for clarification, as I've dealt with, as to the plea of not guilty, which one is entitled to do, and to put the state to the proof and the lack of remorse, and that Your Worship also clarified the substantial contribution made by the accused to the community with the soup kitchens, and that there are several other soup kitchens. That she had explained that the accused is planning to do it, and he'd given money on his previous birthday to the establishment of funds and charities, which is in the report. Then we say in paragraph 24 that Ms. Thompson was of the view that there was no risk of the accused recommitting such an offence again, based upon the passage of time since the commission of these offences, and in not having done so in the interim, which is something that I've already alluded to. Then, and I think it's important that I clarify this because there seems to be some confusion in the heads of the state in this regard. We refer to general principles of the Constitutional Court concerning sentencing. In particular, we dealt with status of Bakanyani when the death sentence was abolished, and we highlighted paragraph 222, which is something that the state and the supplementary heads also highlighted at the very same point. And the point that I wish to highlight there was, and I'm not going to quote it extensively, is that the state not only preaches respect for the law and the killing must stop, but it demonstrates in the best way possible, by example, society's own regard for human life and dignity by refusing to destroy that of the criminal. So all our sentences are blended with a measure of mercy, going back to the Rabi decisions, etc. We then also on this principle referred to the Constitutional Court decision of EFF versus the Speaker, National Assembly. And we said, and this is the quote from paragraph 235, and ironically they also referred to this in their heads, Your Worship, in the middle of 235. It is after all the embodiment of the legendary Lady Justice, a dispenser of justice who is blind and deaf to images of any reports on the good reputation of the variety of personalities before her, and never misses any legitimate and relevant legal or factual points for or against any litigant. And then this court is required to always display the critical boldness to go against overwhelmingly popular and forceful opinion. And then we also deal with the Constitutional Court decision, finally, Your Worship, of Sengwedi, paragraph 27, 2022 decision. It says, our court must defend and uphold the Constitution and the rights entrenched in it. One of the most important rights from a historical perspective is unquestionably the deprivation of an individual's liberty. The court said in February that conceptually, individual freedom is a core right, the panoply of human rights. The apartheid regime repressively and capriciously deprived people of their freedom, and the illegitimate legislation that paid no respect to the rights to freedom and security of the person. We are therefore constrained to jealously guard the liberty of a person under our Constitution, particularly in terms of Section 12 of the Bill of Rights. So those were the cases that we cited, on general principles relating to sentencing. We then turned our attention, Worship, in our heads to sentencing concerning firearms. And we had regard to the article that my friend had provided to us of Joy, relating to a note on sentencing practice in defense of the unlawful possession of semi-automatic firearms, and that they had utilized the support that there should be a period of incarceration. And we quote from the report, Your Worship, we say, just quoting the second paragraph here, from the investigation it's evident that courts are more likely to impose the minimum sentence in cases where the accused is also convicted of other serious offences, such as murder and robbery. In such cases, little attention is given to the firearm-related offences, as the courts are more concerned with the cumulative effect of the sentences imposed on different counts. They also then refer to the decision of ASMAR. It's on the next page, which we say, from the Supreme Court of Appeals judgment in ASMAR, it appears that the circumstances under which the unlawful possession occurred and the purpose for which the semi-automatic firearm was possessed will play a pivotal role in determining whether substantial compelling circumstances justifying the imposition of a lesser sentence exists. There's reference to Delport and the gradation, which is also referred to Mayorhead, and that there's a quote that the grading of the offence will typically be informed by the risk of harmfulness and the culpability of the offender. But then to make the bold submission that I've already made to Your Worship, that the minimum sentence regime does not apply in this instance, and that's in paragraph 29. We also refer to statements in Malikani, which is stated as reference, and we quote from that decision. But we say what is notable from these cases is that imprisonment is not always the norm. And then we say as follows, that turning to paragraph 33 now, that the case law, we said that sub 1, the circumstances of the possession are a central factor. If the context of the possession is part of an overall commission of violent crimes, the court will generally incline towards a harsh sentence in keeping with the objects of the legislation. That's logical, Your Worship, speaks for itself. If the firearm is used to commit a murder or to commit a robbery, that's far more serious than the firearm that isn't used to commit another serious offence, which is what we submit the case here. Secondly, the purpose behind the possession is also another factor that emerges from some of the cases. We say, while not decisive, it is a factor that the court may legitimately take into account. Indeed, there is a vast difference between an accused who has been asked to temporarily keep a firearm while the owner goes shopping and the person who places a firearm in the boot of his car intending to hide it from the police. And then thirdly, the duration of the possession is a relevant factor. An accused has been in possession of the firearm for a lengthy period, they cannot be treated the same. For sentencing purposes, as someone with fleeting possession of a couple of seconds, fourthly, harm is a critical consideration. Court should consider what the harm is. We accept that possession is in itself a harmful thing, but there are degrees of harm caused by possession, so the court would need to satisfy itself about the harm it seeks to punish. Possession in celebratory context for a few seconds should be considered differently. And that's our submission. And then from the cases, Your Worship will also note from whom and in what circumstances the accused received the firearm also played part. We then quote the Delport decision of Brent's Ward to the gradation, which turned on the circumstances in relatively innocuous possession. And we then turn in paragraph 35, which is the case on discharge of firearms. And we say that they also do not always attract incarceration, and that regardless as to the circumstances in the context of the discharge. We then referred to the decision of State versus Tribune, which Your Worship will remember is the case where the person shot at a motor vehicle in a public area because he believed it was his wife's lover's vehicle, he pleaded guilty and was convicted, given a fine, and appealed even the monetary fine was reduced. Then the second decision that we quote there, Your Worship, which I really referred to, is the Pistorius decision, where there was a shooting in a restaurant in Melrose by the name of Tasha's. Under the table, there were over 200 people in a very confined room of the restaurant. Fortunately, there were no injuries, but there was damage to the floor. There's a Glock 27 pistol, and we said that's the most comparable to you, because we believe the witness was given his firearm back after the incident, and that he was the lawful possessor and handed it over to the shooter, but they told him not to shoot. Explained that in paragraph 37, there were 220 people in the restaurant, so it was full at the time. The accused admitted that he had taken the firearm because he was planning to buy a similar model. His version was rejected. But in that instance, Your Worship, the accused was for a sentence on a CPJ to 3 years imprisonment, wholly suspended. So in respect of the conviction in count 3, which was the shooting and discharge of the firearm, I've taken into account that no one was hurt, that the offence is a serious one, especially in the setting of a restaurant. I do not believe that the degree of negligence in respect to this matter that is not true justifies a sentence of direct imprisonment. We then turned, Your Worship, and we went forward in time to 2021, 29th of April, the decision of Nsami and another of the state, where two policemen were intoxicated, shot at somebody in a public area on a boat, and they were charged with attempted murder, and they were intoxicated, which would be an aggravating factor. That we were not guilty, that the versions were not accepted, and they received on appeal for a sentence of 7 years of mandatory fine from Escape Jail of 12,000 rand and 2 years imprisonment that was wholly suspended. This was also referred to by Ms. Thompson, and we then highlighted the factors that we say they highlighted in that case, that no wounds were inflicted when the offenders discharged with firearms, there were no wounds or damage. Their intoxication was an aggravating factor, as was the fact that they were members of the SAPS. As they said there in paragraph 14, the same incident gave rise to conviction on all three charges. The defendant did not engage in one act and then proceeded to engage in further criminal conduct. And then his Lordship said to effectively punish these as separate actions is in our view contrary to what is dictated by a common sense approach, in view of the fundamental requirement of fairness and misdirection. And there was a regard also, Worship, as in this case, the appellant perceived lack of remorse as an aggravating factor. And there's regard here to the decision quoted by the state in the heads of argument of Hewitt, who says that it's not an aggravating factor that can be taken into account. We then looked at we cited paragraph 18, Your Worship, where the following appears. The question is whether direct imprisonment is the only sentence that would, one, take account of the interests of the victim by acknowledging the harm done to him, two, inflict punishment on the offenders, so that the scales of justice are balanced, retribution, three, cause the offenders to reconsider their way and not commit similar acts in future, in brackets, deterrence, cause other people in society from refraining to commit similar crimes because they witness the offender's punishment if they're suffering a similar fate, that's deterrence. And thirdly, contribute to the improvement of the offender and thus assist both offenders and the society, and in bracket, rehabilitation. But you'll see there the definition in 19, Your Worship, in the minutes. This occurred in a moment of madness, what they referred to. And the defendants do not seem to grasp the seriousness of their conduct. There's no evidence of any premeditated actions. There's then a quote from State v. Rabi, 1975 decision. It says, punishment should fit the criminal as well as the crime defect to society be blended in the measure of mercy according to the circumstances. Then we have set out paragraph 20. I'll just quote certain aspects of it. The fourth line, the goal of rehabilitation is to address the underlying factors that led to criminal behavior and by so doing reducing the likelihood of reoffending. However, this objective is generally not met by imprisonment. On the contrary, evidence shows that prisons rarely rehabilitate individuals but tend to further criminalize individuals, leading to reoffending in a cycle of release and imprisonment, which does nothing to reduce overcrowding in prisons or build safer communities. We go further down in that quote, the community is protected when convicted persons are removed from society. However, protecting the community from offenders does not necessarily require imprisoning the offender. And this purpose may be fulfilled through the imposition of other sentencing orders. We are of the view that the facts of this case do not support the finding that the offenders are a danger to society. It calls for the protection of the community through the incarceration as a specific aim of the sentence. And then we quote throughout the paragraph that, once again, in paragraph 21, that it was mainly an act of stupidity, that the offenders acted in the spur of the moment while under the influence of alcohol. We then referred here to the decision of Bader versus S, which involved pointing of a firearm, assault with intent to do grievous bodily or reckless endangerment to prevent the property pointing of a firearm, in which a fully suspended sentence was imposed. So we say, with respect, that possession doesn't necessarily carry in its own a jail sentence. Then there's the new decision, Worship, that unfortunately, and I apologize, have not been included in our heads of argument. I gave a copy to Norbert this morning. it's a decision of the Eastern Cape Division, so it will be binding upon this Honourable Court in Mthatha to the Ports and Trans Circuit Court, decision of Brooks of this division, where in summary, Your Worship, a security guard that was in his 60s and had battled to find employment, was now working as a security guard. He was alerted to two youngsters, or to a bunch of youngsters that it seemed had gone into a media room to try to steal things, and he ran after them and he shot them with an illegal firearm, Your Worship. He killed the one and injured the other. They were 13 years old. In that matter, the Honourable Mr. Justice Brooks imposed a non-custodial sentence, a fully suspended sentence. So we say that's a case, Your Worship, in this Honourable Division, where there was not only harm to one 13-year-old victim, but the murder of the other 13-year-old victim, Your Worship, and that person was not sentenced to jail in this division. We highlight, Your Worship, and I know Your Worship hasn't seen this, paragraph 10, where Justice Brooks says the offences of murder and attempted murder rank amongst the most serious of the common law offences. Indeed, there can be nothing more serious than the unlawful deprivation of another's constitutionally protected right to life, or an attempt at such deprivation. However, one must take care not to merely consider the category or the objective nature of the offence. What is required is a consideration of the offence that takes account of all the relevant facts that are peculiar to the incident that defines it. We also refer, Your Worship, with respect to paragraphs 22 and 26. I know Your Worship hasn't had an opportunity to see this, so let me read them, Your Worship. 22, the Court holds the view that all the aspects referred to above constitute substantial and compelling circumstances that would justify the imposition of sentences less severe than the prescribed. Given the irretrievable loss of life, count one in particular calls for a substantial period of direct imprisonment. However, the identification of this principle and objective isolation at the end of the inquiry. Uniquely, the interests of society in the context of the rural community means the death of the deceased do not necessarily require ongoing retribution for what has occurred, nor do they require that the community be protected from Mr. Malema by his removal from their midst. He is not a person who has shown a predisposition towards criminality that requires him to be rehabilitated or reformed. He poses no danger to his community or to society at large. He has made the necessary overtures to make peace with those families whom he offended by his reckless action. Obviously, the pain felt by the family of the deceased encounter is real and ongoing. Perhaps this will only dissipate with the gradual passage of time. It's not something that can be eradicated by the ongoing incarceration of Mr. Malema. In 26, the three offences arise from a single incident. It is appropriate that the sentences imposed in respect of each offence should run concurrently with the other sentences to be imposed. For the reasons set out above, the court is of the view that the sentences imposed upon Mr. Malema should be wholly suspended for a period of 15 years on condition that he is not convicted of any offence involving violence committed during the period of suspension. Then we come to the conclusion, Your Worship, where we say, prior to that, we deal with general principles concerning sentence, Your Worship. Just the issue of S versus Ora and another proportionality is important. We've got the custom circle, which was acknowledged by Sadi Wallet J. Finding inappropriate sentences is a challenge faced by criminal courts daily. A sentencing is not a perfect exercise. What complicates this even more is that there may be more than one appropriate sentence in a particular case. And then there's reference to a footnote that sentencing at the best of times is an imprecise and imperfect procedure. There will always be a substantial range of appropriate sentences. But what we say, Your Worship, in 45 is that we illustrated that mere possession and discharge do not always mean that there must be incarceration. Each case must be evaluated. In fact, the facts of this case are indeed unique. And we say first, the possession cases frequently attracted either suspended sentences or fines. Secondly, discharge cases have also frequently attracted either suspended sentences or fines. And And thirdly, principles of sentencing are always applicable. Sending a person to imprisonment merely because they possess a firearm with discharge is contrary to the law. In our view, there's no obligation that the court has to imprison somebody for these offences. And then in the conclusion, Your Worship, we say that this was that we adopted cumulative approach, and there are 5 charges, all happened in one single event which lasted no more than 2 minutes. To send any person to prison for the single event would be shockingly inappropriate, that it can be dismissed out of hand without more. We say the lawful and appropriate sentence because cannot include a custodial sentence. Only a non-custodial sentence would be compatible with the principles of sentencing in South Africa. A deviation from that approach would simply show the accused to be singled out from duty harsh punishment. And we say that this submission is fortified by the objective fact that there were no injuries sustained by anybody, no damage to any property. It is also underscored by the fact that this is a single continuous event of no more than 2 minutes and caused no harm to anyone. No court can tolerate the imprisonment of anyone for this incident. In fact, nobody testified that they were in fear of the accused by virtue of the offences committed by him. And we also highlight, Your Worship, that no evidence was there in the aggravation of sentence. Now, Your Worship, as previously alluded to, and this is quite difficult, but I do respect what Your Worship said, that these factors ought to be placed on record, so that there's a record of everything that was just referred to it, and the public don't know what was referred to in the heads would be unfair to the public. So we turn then, Your Worship, to the state's heads of argument. As I said, Your Worship, they highlight the charges or introduction as the green, and they're of the view, Your Worship, in contrary to what we say, that the custodial sentence is inevitable. And they say, and this is where they have a, with respect, self-defeating and mutually exclusive argument, where they say the accused personal circumstances is ordinary. In the very next sentence, they say he is the leader of a political party. So on the one hand, and this is the conundrum that Your Worship grappled with Ms. Thompson, is on the one hand you say because he's a leader, he must be treated differently. On the other hand you say don't treat him differently, treat him like anybody else. And that's the general vein throughout their heads of argument and their supplementaries. And this is borne out in paragraph 8, where they say there's a huge outcry from civil society that should go to book for his crimes. So you can't say, you can't treat him differently, acknowledging that he's the leader of a political party, but don't take that into account, but at the same time society is paying for his imprisonment. They then refer to the listed decision, Your Worship, which I've already referred to, where we acknowledge that imprisonment is a form of punishment and that it's an institutional punishment, not cure. We say that it isn't consistent with a more enlightened approach to sentencing before our court in the post-constitutional era. That was a 1993 decision, Your Worship. And we then, they then deal with the probation officer, and they try to say, Your Worship, that she said there's no case where a person is convicted of possession and evaded job. And that's not in the record, Your Worship. I know the question was asked, but she didn't answer it or make that concession. If I can turn to the record, Your Worship, to just show that it's not the case. I know that this is in their supplementary as well.
Okay.
At page 96, my benefit says, and he's going through a particular case, yes, there were 2 firearms. The one was sentenced to 15 years, one of the firearms were reduced. The one that he actually found in the rubbish dump, so it was a spur of the moment decision by him. He did not have it for a long period of time. Still, he got an 8 years direct imprisonment. In this case here, the accused also did not have the firearm for a long period of time, very brief. It does not change the fact that he was still sentenced to direct imprisonment. What do you have to say about that? And her response at page 97, Your Worship, what I hear is again different circumstances. That was also not for a long period of time, it was. I would not know why. The reason is why it was picked up in the spur of the moment's time. But also here, it was not the only firearm that was possessed illegally, which makes it different. And the use, I'm not sure whether the other firearm was used, but in combination, it is always to look at it. The circumstances in total, what I hear what he said, that for me the circumstances again are different. I'm not sure whether it was an illegal firearm, whether it was seized to the state, what happened to it, which may also make it different. And that's the very distinguishing feature here, Your Worship, because it seems from those judgments that my learned friend was referring to, that those were illegal firearms that have been adapted and were then seized by the state. Here, prior to even Your Worship's judgment, the firearm was returned to its lawful owner. Then my learned friend asks her further, when he's pushing this issue, did you come across any case where such as this, in a firearm-related case, possession of firearm, where an accused was not sentenced to direct imprisonment, actually got given a fine to pay 20 years, and so on and so on. And she says, as I've not come across, Your Worship, to any case where a charge was laid and the firearm was used for celebratory shots. So she never ever said, yes, I know of such a case, or I don't know. She says, I cannot find a case that's on all fours with this, because this was celebratory. So then he tries hard, Your Worship, at the foot of 97. He says to her, have you come across a case where an accused was convicted of being in possession of a firearm, whether it's for celebratory purposes, that it's just social, for whatever reason? Have you ever come across the case where an accused was not sentenced to direct imprisonment for being in possession of a firearm, whether it's just for a minute, for 10 minutes, for 20 minutes? And the answer is, so 98. Your Worship, I have not, because most of the cases that I've seen were also not only the firearm possession case, but most of them relate is in the context of other crimes that were committed with the firearm. So the possession forms part of that. And then a sentence of imprisonment was imposed for that. I have not come across a case where it was purely just for the possession of a firearm. So Your Worship will know from reading the heads of argument, they infer differently or even say that she wants it differently, which is not the case with this court. In the state's heads, they summarized the Mutloom decision. They also deal with possession of an unlicensed firearm. The Delport decision, which I've already referred to, degradation. The Malchus decision. And now Your Worship, with respect, they've gone to all the cases that deal with minimum sentence provisions. So, and they even refer openly there to the Criminal Law Amendment Act, with the abbreviated CLA, which is Malchus, the minimum sentencing legislation. It continues, Your Worship, even in paragraph 21, when they deal with Madikani, it's the Criminal Law Amendment Act. They got into Dubi, which is the minimum sentence, or there's a well-planned robbery. Asma, which dealt with the very issue of minimum sentencing regime being applicable. And Rantline versus the state, robbery and other offense. In fact, there were 2 robberies. He already had previous convictions and he received 20 years. Sabandi versus the Est, the Temple led to the Glada decision. But you'll see, Your Worship, even in Glada, the serial number had been obliterated in unlawful possession of ammunition as well as 15 years for the unlawful possession of 30 rounds. So we say they're totally distinguishable, and you'll see there, we turn to paragraph 28, there was a prohibited firearm, also the serial number obliterated. And this is the general trend in all of the cases that are referred to here, Richard. So it would seem that they seem to have emphasized cases that dealt with the Criminal Law Amendment Act, the Town case, and it carries on like that with respect, but there's no case that they can point out of celebratory shots being fired and the person receiving a prison sentence. And they also refer to the minimum sentence in paragraph 36 and the Delport decision. So what they say, Your Worship, is that the court must impose a period of imprisonment, that they refer to cases that all, with respect, refer to minimum sentence legislation and are not applicable here. And they say in paragraph 45, this is the strongest part of the case. In this case, the state submits that due to the fact that the accused testified that he claimed to possess the 2 firearms, 9mm pistol and 7-inch rifle, he emptied the 9mm by firing 15 shots, followed by 7 shots from a rifle. That there was a crowd of 20,000 people at the stadium, including supporters, medical personnel, police officers, security guards, coupled with the fact that there's a very condensed community residing right around the stadium, of facts that place the accused in the sentence category between 7 and 15 years imprisonment. They then asked for 10 years imprisonment, and then finally, Your Worship, they referred to the Zim decision to have asked to be tried, and they say, lastly, the accused has treated the proceeding with such contempt, took the citizens of South Africa for fools by trying to convince all that he fired a toy gun, blamed everyone except himself for his actions, confused the law with politics, practiced all intimidating tactics by hiding behind crowds, dragged everyone to be participants in his show. The show is over. This court must send out a strong message to other would-be offenders who fire shots among crowds and endangering the lives of others, that if you commit a crime, you must do the time. And that's the conclusion there. Then, Your Worship, as I already said, they filed the supplementary heads of argument last Thursday, and there's a lot of, with respect, repetition, Your Worship. You'll see the introduction is very similar. They highlight the charges that he faces, and they concede in paragraph 4, and this is where they go against the previous heads, that the minimum sentence legislation does not apply because he had not been warned accordingly. But they ask the court to impose a custodial sentence, and they do the aggravating features of the case, and they repeat everything that they said in the previous heads. There's nothing with respect to new, so I don't know what the supplementary about this, Your Worship. With our heads of argument and to respond to the heads of argument. Case involved a public leader who claimed to discharge live rounds from 2 firearms before 20,000 people as a rehearsed act of spectacle. And once again, Your Worship, I highlight, they tell you all along, treat him like a normal person, but they keep highlighting with respect that he's the leader of a political organization and you must punish him accordingly. So it's self-defeating with respect. They then also, in paragraph 10, they have a heading beneath it, 2 firearms, 22 live rounds before 20,000 people within a community. And they refer to the firearms being a 9mm handgun, Narinka SPA 249-14, 5.65 by 45mm, Remington semi-automatic assault rifle. But Your Worship, what they failed to record here, or even consider, they gave that back. So if they believe that an offence had been committed, Your Worship, and it was so heinous and it's a prohibited item, I don't understand the sense of having returned it to its lawful owner, but that they don't have any regard to. And they say that such a firearm, in paragraph 11, retains lethal kinetic energy on descent. The potential for mass casualties was real, foreseeable and scientifically established, but we have the objective fact, Your Worship, and they say that it's pure fortune, that nobody was injured and there was no damage whatsoever, Your Worship, which is a factor that this court took into account in the judgment and ought to take into account on the sentence. It's one of the most important factors we're taking into account. And that's what they say in 12, Your Worship, that no one was killed or seriously injured. It was a matter of fortune, not mitigation. And then, Your Worship, in 15, they say that this conduct is a harm to the values of constitutional democracy itself. And in 16, again, they say the court is therefore called upon not only to punish the accused for his individual conduct, but to vindicate the constitutional principle that public office and political prominence do not confer immunity from criminal sanction, which is the point that I'm making repetitively because they seem to go between those two approaches with respect to it. They then also refer to the decision of Hewitt as did we, and then they claim that the accused not only had an absence of remorse but also insight and accountability, and that he had maintained throughout and continues to maintain that he committed no offence despite being convicted after full trial on overwhelming evidence, which is the issue that Your Worship dealt with on record and recorded that it was his right. And then they say that he described these proceedings as an abuse of the NPA resources, an incompetent prosecution attributed the undisputed discharge of 22 live rounds
recently. But in 20 they say that firstly and most significantly, Ms. Thompson conceded under cross-examination that she could not find a single case in the literature where a non-custodial sentence had been imposed for the unlawful possession of a semi-automatic firearm. This concession is remarkable. It speaks not to the uniqueness of a lenient outcome, but to the settled judicial view that such offences call for custodial sentences, a view Parliament endorsed through the enhanced penal jurisdiction in the FCA. Now that cannot, with respect, be correct. We've handed, my learned friend wasn't aware of it, which I do concede, the more recent decision of the Eastern Cape, to worship, where there was possession of an unlawful firearm. It was an illegal homemade firearm, and there was no custodial sentence imposed, and we dispute that such a concession was even made, Your Worship. We don't find it in the record. I know that sometimes the records aren't 100% accurate, but my learned friend can elaborate on that, because that appears from his supplementary that's filed last Thursday. Then they deal with the issue of Ms. Thompson's recommendations premised on a characterization of the possession as brief, benign, and celebratory. On the brevity, they say the brief duration of possession is relevant only where possession is accidental or fortuitous. They say here it was pre-planned and deliberate. Benignity, 22 live rounds. They said the ballistic risk was extreme. Celebratory purpose, they said the law does not distinguish between a reckless act done for enjoyment and one done for malice in assessing objective dangerousness. The rest we say is a repetition, but then they say, Your Worship, in 22. Fourthly, Ms. Thompson's assessment of the risk of recidivism was superficial. She relied on the mere passage of time since the offence. She did not grapple with the fact that the accused, who leads a political party that has staged multiple large-scale events since 2018, has demonstrated no acknowledgement that his conduct on 28 July 2008 was dangerous or unlawful. The absence of reoffending in the interim is not on its own indicated that no such risk exists. Now, recidivism is defined as the tendency of a convicted criminal to reoffend, relapse, or go back to its way. And that's the clearest indication is looking back on time to say did such a thing reoccur. So we submit that Ms. Thompson is accurate in that regard, and they, with respect, seem to have misinterpreted the term recidivism, and it wasn't superficial, because we look back in time, we say, were any other offences committed in that time, in the past 8 years? And the answer is no, because the clean SAPS 69 was handed in, so it doesn't appear that she's inaccurate in that regard. They then respond to our submissions, Your Worship, on sentence, and they dispute that celebratory discharge cases are distinguishable. They say that you do have outcomes where there are no thing, but they say they're distinguishable. And then, as dealt with in their previous heads, Your Worship, they're saying Pistorius, there was no premeditation. In Munsani, the accused intoxicated police officer fired at a canoeist in a moment of madness. Fordyun was a crime of passion. Bader was a firearm and reckless endangerment, not discharge. So they say they're all different. And we say, yes, Your Worship, at the same time, and the most glaring fact, Your Worship, is they could not find one case in our whole history of all our cases, Your Worship, of shots being fired at a funeral or a celebration that resulted in a prosecution. And that's a fact that stands out on its own, Your Worship. And then they say the no harm, no injury argument misrepresents the nature and gravity of the charges. And they say no one was injured, no property was damaged. The state acknowledges this, and that this they describe as being purely fortuitous. But what they don't mention here, Your Worship, and Your Worship went through the trial, so Your Worship knows, there was not one eyewitness that came to testify before this honourable court. The state was dominus litis. If anybody was in fear, out of all those 20,000 people that they now rely upon, it was incumbent upon them, either in the trial, Your Worship, or even in aggravation of sentence, to lead that evidence, but they didn't. Even the SAPS who were on the stage, Your Worship, were not called by them to testify, even in aggravation of sentence, Your Worship. Not even the Gearhouse people, Your Worship, said that they feared or were worried for their lives or ran away. No single person stood before this honourable court saying, I was afraid of being injured. I saw this as reckless, callous, and dangerous, which is something that they ought to have led if they wanted to prove that there were aggravating circumstances. They then, Your Worship, tried to fall back on their previous heads of arguments and say even where the minimum sentencing regime does not apply the case law, establishes a clear sentencing range for unlawful possession and discharge of semi-automatic firearms. They then quote our constitutional cases that we quote, so the principle is clear from that from the case of Makwanyani, Your Worship, and EFF versus the Speaker. Then they turn to the personal circumstances of the accused, and they say it's a double-edged factor. It may be often in mitigation of personal circumstances that is a public leader and member of parliament, but they say this is the most significant aggravating feature of the case. So now, Your Worship, they argue, treat him like any normal human being. At the same time, they say, no, this is the single most aggravating factor of the case. The two are mutually exclusive with respect, Your Worship. They acknowledge, Your Worship, in F, that all 5 counts arose from a single continuing incident, but they say the remaining counts serve to aggravate the primary count, not merely to establish its context. And then, in their concluding submissions, Your Worship, they go back with respect to the imperative of equality before the law. So you asked on the one hand to make an example of this accused because he was the leader, current leader of a political party. Then they tell you, no, there's an imperative. You must make us all equal before the law. And they say them themselves, they say, sentence that treats this case as an exception to well-established sentencing norms would itself be an act of unconstitutional discrimination against the poor in favor of those with means and the powerful. Now what we're saying, Worship, is they seem to imply that to impose a fine would be unconstitutional. It's not the case, Worship. You can impose a fine. It's recognized even in the post-constitutional era that a fine is a punishment, as is a suspended sentence, as are other forms of punishment. They are recognized. Then they ask for the imperative of proportionality and the imperative of deterrence. And then they repeat themselves, Your Worship, in paragraph 35 yet again, where they say, and I'm going to quote because you'll see just how many times they've said this, the accused has treated these proceedings with contempt. This is from the previous head, Your Worship. He fabricated a false account of a toy gun that was comprehensively dismantled by the overwhelming evidence at trial. He refused to cooperate with investigators. He characterized this prosecution as an abuse of the NPA. He blamed VIP protectors, the Holy Spirit, and everyone except himself. The show is over. The court must now ensure that justice is done, not because the accused is prominent, but because the rule of law requires that every person who commits a serious offense faces a serious consequence. And they therefore go back to the zin as they did in the previous heads and ask Your Worship to impose. Now, Your Worship, what's lacking from all of this, and which leads into the allegation by the accused that this is an abuse of the NPA, is the objective fact, Your Worship, that we as a team and the state as a team, and I believe Your Worship too, were unable to find any case of any single individual who's ever been prosecuted for firing shots at a funeral or at an event or a celebration, despite all of us having seen that regularly on our TV, on the news, etc., etc. We therefore say, Your Worship, that a more appropriate sentence, taking everything into account, would be to take all the charges together, they arise from one incident, and to impose a non-custodial sentence which may incorporate a fine and a suspended sentence and any other order, but to incarcerate the accused, we say, would be startlingly disproportionate to the offences here, Your Worship. Thank you, Worship.
Thank you.
I now have another right of reply. My little friend's in a difficult position because his heads have been alluded to, but I'm sure he's going to add to them as well and deal with.
Yes, and then obviously you may reply
Yes, Your Worship.
if something.
I think Mr. Guy told you will do the reply, Your Worship. With your leave. Thank you.
Advocate Olive, there's just one aspect that I want to ask since you've raised it now, and I've read it in the heads and heard in the evidence of Ms. Thompson, and that is the part of the firearm being handed back before the court passed judgment. That is not within my knowledge. So,
it is, Your Worship. It's in her report. She testified before.
No, it is in her report. I'm saying it's not within my knowledge. I'm hearing it from the defense.
No, Your Worship. Yeah, there was no evidence. No, there was evidence there. She testified to that.
No, I don't
it's
think
in her report and it's in her testimony. And Your Worship, it's a logical conclusion. My learned friend, who was in court and would be aware of it, never disputed it once.
Yes. No, look, no, maybe I'm not. I heard her saying so. There's evidence by the defense regarding that. I'm just not sure where it's coming from. You don't have to. I accept it's there. And as you say, it wasn't challenged, but it's not within the knowledge of the court that it was returned before judgment.
No, it is, Your Worship. It's in her report. She was led on it. No, I was also astounded by it, so you'll find I've given Your Worship the page reference.
No,
and
I've
the
seen
report
it.
reference.
I know it's there. I do confirm it is contained in her report and
had
in
it-
her evidence.
Had it not been the friend was obliged to challenge her on it, and he didn't. So it's an objective fact, and it's evidence that was laid before this honourable court. I don't know why there's a noise, Your Worship, and I don't align myself with this.
No, it's the
So let me
same.
repeat what I was saying, Your Worship. She testified, as Your Worship knows, it's in her report, and my
Yes.
learner friend was present and never ever cross-examined her on
Yeah.
that aspect. So, with respect, in our submission, it's a proven piece of evidence before this honourable court.
Look, I hear you, I agree, and then I saw it in your heads, and that's why I thought I'll ask, because I'm not sure what the source of that information is, but it's neither here nor there. As you say, it's on record. I'll hear if the state has any reply to it, but it's not. Thank you. It's so noted. Thank you.
Thank you.
All right, Advocate Caesar, are you ready or?
I think we must get this over and done with here, Your Worship. I'm ready.
I know it's inconvenient, you don't have to move. We do have lady staff here who are requesting a bathroom break, which is 5 minutes. We can return within 5 minutes. Don't want to put anyone on the spot, but I'll just leave all my stuff right here, so I don't have to carry anything. Don't know who else, but sorry, the public, the gallery. If you do need to go out for facilities or water, etc., just please stick to the time frame so that we are back in time to proceed, because it's a lot who has to go out and back, and then 5 minutes becomes 15. So I know everyone can't manage in 5 minutes, but I'll be right here. Sorry for that. Let us just allow everyone that.
10 minutes, Your Worship.
Okay, so it's now, let me say, should we now just do the tea adjournment and get it over with? Is that fine? Do you want us to do the tea adjournment now? Then I return at exactly 11:15 and then we go right through. Fine. I can't hear. The defense, is that in order? I
Yes,
can't
Your
hear.
Worship. No, we don't have an issue.
Okay. Court will adjourn until 11:15. Thank you. Oh, if that's the case, then yes, the charge is okay. Then I'll take that stuff. Sorry, before you proceed, we just want to check if the file is interfering with the recording at all. We hope not. And then we'll be ready for you. Please be seated with the mic. Fine. Okay. All right. You may proceed, Mr. Caesar. Everyone from the defense also ready to proceed? Thank you.
Can Your Worship just inform everybody again that the cell phones must be switched off or on silent?
The gallery, you heard that? Is our interpreter here? Ms. Mavwa, please. Thank you. Just a minute, sorry. I'm ready if you are.
Thank you, Worship. Your Worship, I don't know how council expect me to impress my bosses if he has done half of my job for me. One thing is certain, I'm not going to pay him 1 cent for that, Your Worship, for doing or attempting to do my work for me.
Please go ahead.
It was when I was at the magistrate's course many years ago. They had this 3D dimension on the board where we each were required to say or what exactly was on that particular 3D dimension. Some saw elephants. I saw a head of a man, an old man. Even some saw a lion, some saw 3 heads. The point that I'm trying to make, Your Worship, is that we're looking at the exact same set of facts with different views relating to that particular fact. That is the court's duty to find which one is the more plausible argument. It's not for me to minimize counsel's argument and vice versa. There's just 2 aspects that I need to rectify right from the beginning. The issue relating to the filing of heads. My heads, I confirm it was filed on the 1st of April. The issue that I need to address is the condemnation issue, because I did call Mr. Mkwanazi on the 31st informing him that my heads are ready, it's ready to be filed. I wasn't in office, I was on the road, and I did not want to send unsigned heads, which he confirmed that there will be no issue. Why counsel raised it like I had to apply for condemnation? To me, that is sufficient. It was filed first thing on the 1st of April when I got back to the office. The second issue that I also relating to the condemnation, I did not read counsel's heads on the 31st. Reason being, as I already explained, I was on the road. I was not in office, I was unable to read it. That's the reason why I contacted the attorney, Mr. Mkwanazi, because I did not have any other person's number. It's my view, a response to the heads of counsel in the supplementary heads. There's no need to apply for condemnation on that aspect. That's a matter for debate. The second issue that I want to address is relating to the firearm that was given back to accused number 2. It was given back to accused number 2 on the day when he was found not guilty. There was a prior agreement between the attorney for accused number 2 via emails that was sent to one another between me and that should accused number 2 be found not guilty, that the firearm would be returned. If he was found guilty, the position would have changed drastically. The issue about the firearm being given back, it's our submission that that is a storm in a teacup. We are fully within our rights. If you read Section 30 of the Criminal Procedure Act, Section 31, which allows us to give the firearm back if there's no need for the firearm to be kept further. If I might read, just to assist counsel, what this particular section says relating to that. Sure. Bishop, I don't know if it's the lights or what.
I think it's the bright light behind you may cause a glare, I'm not sure.
If can I ask my learners, because it's so, I will actually ask counsel to read that particular part for me. You must read section 30 and then section 31(1), because I can't see, I don't know if it's the
Just
light.
borrow someone's spectacles that you can see them.
It's time, it's time.
It's time that you go and get spectacles.
Sure.
Oh, he's got
No.
them there, look.
This, you should,
Sorry.
I
Oh.
got the spectacles.
Now we
it's
we
much
are in a
better.
spectacle. All
Much,
right.
much better. Section 30 deals with disposal by a police official of an article after seizure. A police official who seizes any article referred to in Section 20, which we know it's articles which they lawfully are entitled to seize from an accused or a suspect or any person who is suspected to have committed a crime, to whom any such article under the provisions of this chapter delivered may, if the article is perishable, with due regard to the interests of the persons concerned, dispose of the article in such a manner as the circumstances may require, or may, if the article is stolen, property or property suspected to be stolen with the consent of the person from whom it was seized, deliver the articles to the person from whom, in the opinion of such police official, such article was stolen, and shall warn such person to hold such article available for the production at any resultant criminal proceedings if required. I'm not going to lead the last one, C. I'm going to go to Section 31, subsection 1A, that deals with this particular issue. If no criminal proceedings are instituted in connection with any article referred to in Section 30C, or if it appears that such article is not required at the trial for purposes of evidence or for purposes of any order of court, the article shall be returned to the person whom it was seized, if such person may lawfully possess such article, or if such person may not lawfully possess such article, to the person who may lawfully possess it. We had no need for that firearm anymore after accused number 2 was acquitted. They didn't need to come and apply or bring an application for the court to make such an order. We did not deem it necessary. It was well after within our rights, after consultation with the investigating officer, that such article be returned and that it be warned that such article may be made available maybe at a later stage. That is exactly what happened. It's my submission that this issue about the firearm being returned is a storm in a teacup, because we were perfectly within our right to return it. The investigating officer has retired. if that article went missing in his absence, it would have caused a greater problem. So that's why the decision was taken to give him the article after he was found not guilty. Ms. Thompson's evidence regarding that particular article, she was not cross-examined because that is evidence that she got from the accused or whoever was informing her that that particular article was given back. It's the same storm in a teacup that was made about the laptop where the video evidence was stolen, despite the fact that it was kept on another hard drive. The laptop was a non-event, so we didn't need to focus on that particular issue. The evidence was still there, it was already collected, just as the article prescribes. Since that issue now has been dealt with, and the law allows us to do so, I want to deal with the issue relating to Section 9 of the Constitution, because that is where everything starts. It guarantees equally before the law and the right to equal protection and benefit of the law. In the context of criminal offenses, the Constitution obliges the court to protect and promote the rights of every individual, ensuring that no person is above the law. I will get to this particular part in a later stage, just to respond to what counsel was referring to about the double-edged sword relating to the accused being treated equally before the law like anybody else, and the fact that we mentioned that he was a public figure and that he should get a more severe sentence than the normal man on the street. Insofar as sentencing was concerned, the court is well aware that courts are obliged to take into account the aim of sentencing, which is retribution, rehabilitation, prevention, and deterrence. The court must consider the personal circumstances of an accused, the seriousness of the offense, and the interest of society. I'm not going to go through my acts page by page, but we have referred to State versus Banda and others.
Sorry, Advocacy, so I follow you. Are you doing a combination of the first and second, or which one are you busy with now?
I'm busy with page 2.
Of the first one?
Yes, it's the first one.
Thank
First
you.
one.
Just so I can follow you. Thank you.
Yes, the accused's personal circumstances was well articulated by the probation officer, Ms. Thompson. I will deal with the flaws of her evidence when I refer to my supplementary heads of argument. It seems that basically she relies on those factors that the accused did not injure somebody, that he possessed a firearm for a short period of time, and then she made the recommendation, because he also have a soup kitchen that he is responsible for, that he should get a non-custodial sentence. I want to add to this point, Your Worship, that I also received the matter, the judgment on sentence of Justice Brooks this morning. I am going to go through it, but I will deal with it briefly, just briefly. If the court allows me time to read it properly, I can produce many similar judgments of the same judges in the same division where they differ from opinion, which is within their right to do so. I didn't deem it necessary to hand this particular judgment up by the DJP, the Deputy Judge, now retired Judge President Van Zyl, where he has an opposite view regarding firearms, the matter of, it's an appeal matter, a full bench appeal judgment, the matter of Romeo Jansen, the case number, it's CANR 220/18. I just want to see the date when the judgment was delivered on the 29th of August 2019. This is a full bench matter where he held the exact opposite view of what Justice Brooks held regarding the possession of firearm, and this already outweigh the judgment as counsel has handed up of Mr. Nolan Linzima Ndila, because this is a full bench judgment of the same division. I'm going to give counsel a copy as well, if I may hand it up for the court's benefit. Your Worship doesn't even have to be concerned. The fact that that judgment already outweighed this one, which is by a single judge, the court can rest assured, because the Supreme Court of Appeal already dealt with this particular issue relating to firearms. We know that the Supreme Court of Appeal is the highest court, and then the Constitutional Court, the apex court. So the reason why these judgments are relied on by the Supreme Court of Appeal, because of these different judgments from different divisions talking about the same issue, having a total different view. Like I explained earlier, how you can look at the exact same picture and see a different thing. He differs from Judge Brooks, gave a direct imprisonment, quite a substantive one in that Romeo Johnson appeal matter. Your Worship, I want to be upfront that the state is seeking a custodial sentence, and if we can get the maximum sentence of 15 years, counsel correctly said that we do not rely on the Minimum Sentence Act. We do rely on section 121, which refers to the maximum sentence of 15 years. And I'm going to tell the court why we are relying on that particular sentence, or the request to impose at least a 15-year term imprisonment. Your Worship, without being prescriptive, it is correct that the custodial sentence will send out a clear message. Counsel referred earlier about this happen regularly, where people just send fire shots at events, at funerals and so on. I must say, I only saw it on television once, is the one that was highlighted by the Deputy Mayor, I think, of the Nice Now George municipality. The outcry because of that shows that that should not be tolerated in a civilized society, where people's lives are placed in danger for people who are in a celebratory mood firing shots. And in most cases, these people are unqualified to fire such shots. In this instance, accused did not just fire one shot and left it at that, which we can consider to be an accident. He was malice, to say the least. His actions constituted extreme danger to the 20,000 plus people that were present, not even mentioning the community right around Mdantsane, which we know is one of the biggest locations in South Africa. It's condensed, it's densely populated, and especially on a weekend, it is busy in Mdantsane. It was by the grace of God that nobody got hurt.
I think I repeated that I said this on the 23rd of January. If there is such a response, I'm not going to ask you to be quiet. I'll order you to leave. There won't be a choice. Understood? Please interpret, Ms. Margot. You may watch outside if it's going to cause a delay and no noise. Ms. Margot? Advocate Caesar, you may proceed.
Thank you so much, Your Worship. The accused is a political leader. He's got a huge following. Young people emulate this type of behavior. What he doesn't realize is that he already opened a Pandora's box where he creates the impression that this type of conduct is acceptable. What did Pastor Moro did do? He grabbed the firearm, ran to a school, screamed it was a toy firearm. Deputy Mayor of the Lanista George municipality fired shots, screamed it was a toy firearm. That's the president that he said. That people think they can get away with doing this type of offenses. Courts said to the clear that such barbaric behavior should not be tolerated. Accused is a member of parliament, a lawmaker. Yet he's the one that broke the law. If it was anybody else, you would have screamed that that person should go to prison. But now the foot or the shoes on the other foot is screaming, give me a custodial savings. This council already mentioned what I was about to say in most of these cases. But what I want to read to the court is the case on paragraph 4, on page 4, paragraph 10 of my heads of argument, which is one of State versus Lister. The citation is in my heads of argument. This issue particularly deals with Thompson's evidence, and our court should use such particular evidence. I want to quote, I remain unpersuaded by the submission in counsel's heads of argument that the court should have adopted the opinion of Dr. Sidley that Sego's sentence would undermine the treatment in which she would have to submit herself. Present, one knows, is not a continual place, and the conditions may well be less than ideal for psychotherapy. But then, a prison is primarily an institution of punishment, not a cure. As a court of law, was it pains to point the approach of a sentencing officer is not the same as that of a psychiatrist, and if I might add, also a probation officer or a social worker. A sentencing officer takes into account all the recognized aims of sentencing, including the definition. The psychiatrist is concerned with the diagnosis and rehabilitation. The psychiatrist is concerned to focus on the well-being of an accused at the expense of the other aims of sentencing, so the interest of the community as a restored process, and to produce, in all likelihood, a warped sentence. Now I went through the Oxford Dictionary to try to understand what this word warped means. It's something twisted. Bent or must have something diverted from its original form. It also refers to a distorted it's abnormal. I'm definitely going for an eye test after this.
Please do.
I'll give you now for a while. It refers to a distorted, abnormal, or perverse mental state, or sense of humor, or twisted moral values. If the accused get a non-custodial sentence, but this is basically what a law now would go to. It will tell people that it's okay that if you fire a shot, whether it's 1 or 2 or 10 or 15 or 20, it's fine, you'll just get a fine, non-custodial sentence, because this is what the type of sentences the courts are imposed. Whereas it's my submission, it's not. All the cases that I've listed in my heads of argument, all the accused got direct imprisonment. Counsel also stated that I referred to the Minimum Sentence Act. I don't see it was not wrong. The fact of the matter is the point that we were trying to make, that the Minimum Sentence Act and the Mahal judgment is at pains to explain that court should impose standardized sentences, whether it's minimum over 15, 15 and up, or maximum 15 and down. The sentences should be more or less the same, depending on the facts of that particular case. I did not refer to my past because I wanted to report attention that you should get the court's attention to the Malchus case to inform the court that that's basically what it boils down to, that for certain type of offences, standardized sentences, whether it's minimum or maximum, should be imposed. That was the intention of the legislature. In State versus the airport, I'm at page 5 in my head. Paragraph 14. I quote, there will undoubtedly still be a gradation of seriousness taken in the unlawful possession of firearms. In this respect, much will turn on the circumstances in which the unlawful possession occurred. There will be cases in which it will be evident that the possession, although unlawful, was relatively innocuous, and that the weapon was unlikely to have been kept or used for any nefarious purpose. It refers to a sentence of 15 years imprisonment in such cases is clearly disproportionate and irreconcilable with the constitutionality of the implementation of the prescribed legal sentence regime. There will often be an evidential burden on an accused person to give an explanation showing that his possession of an unlicensed firearm was relatively benign. That will be all the more so when the weapon concerns prohibited weapon. We know these were two firearms that were fired. There was a submission that nobody came to come and testify. Already, we argued this point already. We had all the evidence, the video evidence was the silent witness. It gave us everything that we needed to know. No witness would have been able to describe everything that we saw on that video. To rely on the fact that no witness came to complain and so on is neither here or there, or that we did not call any witnesses in aggravation of sentences, either neither or that. The video speaks for itself. They say a picture speaks 1,000 words. This is one of the instances. I always have an issue when I see words like obnoxious and so on. I like to consult the dictionary to understand what is this person trying to say when he uses words like that. The word in this obnoxious, in this context, is meant not harmful, injuries. It describes something safe, inoffensive, or unlikely to cause disapproval. It often refers to remarks, behaviors, or substances that seem harmless, but may not be. Synonyms include harmless, safe, innocent, inoffensive. We know for a fact that this firearm was not fired, both of them were not fired innocently. This accused testified, he planned it, and when asked why did you choose a particular direction to fire, he says, don't tell me how to fire a shot. I can fire it even from underneath the stage if I feel to do so. It is not innocent. His intention was clear. He was going to do whatever he wanted to do, regardless of the circumstances and the situation and the danger it might have posed to the people around him. It was on the video, it was clear people were running. He disputed it until the last minute, but the evidence was there, we've seen it. There were 7 people in the direction, 20,000 right around where he was standing. For him to rely on the police and against this background that sentencing for firearm-related offences in terms of the minimum sentence regime must also be viewed. The question arises as to whether a standardized and consistent result, as was envisaged by the Malchasme, has indeed been achieved in respect of sentencing for the possession of semi-automatic firearms. We know that this one was an assault rifle, despite it being semi-automatic. Its size of the ammunition is dangerous. It's bigger, it's more powerful, and could have had fatal consequences. So the Supreme Court of Appeals referred to the tendency of the courts to use, even only as a starting point, historical sentencing patterns as a provisional standard for comparison when deciding whether a prescribed sentence should be regarded as unjust. Again, like I said earlier, it's neither whether it's a minimum sentence that's applicable or maximum sentence, but a standardized approach to sentences for certain offenses. I refer to all the judgments that counsel assisted me, Malikane, Asma, Romslai, Sibanda, Lata, Tumo, Lahi, Fatwe, Lordo, Tau, Mukovo, the judgments that is closer, in my view, to more or less the same similar circumstances, not the firing. I don't want to be misunderstood when counsel reply. It's not the firing of the shots for celebratory purposes and so on. I don't want to be misunderstood. But what I understand, what I want to point out, these people did not have the firearm for long periods of time. I have referred to it in my cross-examination of Ms. Thompson if the matter of State versus SWAT, where the appellant was convicted on 2 counts of unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on one of the counts in view of the fact that the appellant reported a denial of possession, which the denial was found to be false, which is the same as this instance. He said he had a firearm, he said it's a toy. He still maintains it's a toy. Regardless of the evidence, already overwhelming evidence proving otherwise, that this was indeed a real firearm owned by the owner, which we gave the firearm back to, which was ballistically linked. Back to after he was found not guilty and discharged. And furthermore, that no mitigating circumstance in relation to his possession could be inferred. The court held in the SWAT case that there was nothing to place in unlawful possession of the firearm in a less heinous light than that which motivated the lawmaker to lay down a minimum sentence of 15 years. However, a further count of unlawful possession of a semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. This gentleman had 2 firearms. Ms. Thompson testified, said, 2 firearms, not taking into consideration, even when it was pointed out to her that the accused fired with 2 different caliber firearms, which he denied that he knew that the one was smaller or bigger, something that was so obvious to see. I don't know firearms well, but you know one is a rifle, the big one, and one is small, it's a handgun. In this regard, the court held that the state accepted the appellant's version to the effect that he cautiously came across the firearm in a rubbish dump and was apprehended the same day. Mr. Thompson was saying that we didn't know how long did he have it, and all the fact of the matter is a day has got 24 hours in it, and he was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made in the spur of the moment. Furthermore, it was held that the appellant did not have the firearm in his possession for a very long before he was apprehended. He didn't have it long. Same as was reviewed by Mr. Thompson, yet this is the sentence the appellant was given. One was 15 years in respect of the one firearm, then on the other firearm, the sentence was reduced to one, my memory serves me correctly, of 7 years in prison. The court held that if the circumstances of the crime were such as to make a sentence of 15 years imprisonment as proportional. That was the one that he did not have for a long time. The other one, we didn't know how long he had the firearm in his possession. What I want to point out in this particular matter is not said whether he fired shots with this particular firearm or not, or whether he used it in the commission of further offenses. My memory serves me correctly, counsel, I totally did point out that matter. It's just I can't remember what exactly was said regarding that particular point. But the fact of the matter is that he did not have the firearm for a long time. So State versus Dialport, although dealing with a fully automatic firearm, when J expressed reservations about the suggestion in some judgment that the possession of a unlicensed firearm should be treated as serious only if the weapon had been used for the commission of the offense. The point that I just raised just before this, it looks like the impression is created that if you have a firearm in your possession, you should commit other serious offenses for you to qualify for a 50-year imprisonment, which is not the intention of the legislature. That's why the Firearms Control Act was enacted, because of the seriousness, and the Parliament deemed it necessary, the legislature deemed it necessary to make a specific act for firearms because of the serious nature that it poses. The legislator did that in order to single it out for harsh punishment. You are already guided by the cases to the Supreme Court. You don't need to really consider all the other cases, whereas there's already authority from the Supreme Court of Appeal saying that harsh punishment should be imposed. In both them, Barreto and Rotlai, Supreme Court of Appeal upheld the minimum sentence for the possession of semi-automatic firearms. So in cases where an accused is convicted of a standalone offense of unlawful possession of a semi-automatic, the courts are taking an increasingly unsympathetic stance towards offenders, and terms of imprisonment with a range of 7 to 10 years imprisonment are commonly imposed. addition, the accused's personal circumstances, one of the most important factors in deciding an appropriate sentence is his explanation as to how the unlawful possession came about. What did he say? He's planned it all along, even the EFF planned this all along, that this is what they're going to do for show, to entertain the crowd, not taking into consideration the consequences it might have caused. And it's no wonder the accused went right to the right side of that stage, firing those rifles, realizing there's only a minimum of 7 people that were standing there. It seems that the judicial sentiment increasingly does not support the view that possession of an unlicensed firearm should be treated as serious only if the weapon has been used in the commission of the offense. And in this case, we know for a fact that he did not, he used it. He was found guilty of all the other alternative counts or the other counts because he has used them. He was charged for that and he was convicted of those offenses. I've already alluded to the fact that there were so many people there and the danger that the accused posed to their community, the supporters. Therefore, the state prays for the maximum sentence of 14 years imprisonment in light of these aggravating circumstances and factors that are already pointed out to the court. Without being prescriptive, the court, in respect of the possession, unlawful possession of a firearm, the accused should have actually been charged being in possession of at least 22 of those live ammunition, because if the logic dictates if one of those were linked to their firearm, it should have been 7. Logic dictates that the other 6 that went out before them was also live ammunition. In respect of count 3, 4, and 5, the state will submit that fines may be imposed on those sentences and will not impose such type of sentence, and that these sentences, because of what it's in a single event, different counts arising from one single intent, that these sentences may run concurrently. Counsel said this already when he read my next paragraph 47 on page 30, as I was concluding that the accused have treated this proceeding with such contempt. He took the citizens of South Africa for fools when he tried to convince everybody that he fired a toy gun. Everybody can see that it's not a toy gun. Blamed everybody for his actions. He confused the law with politics. He practiced all intimidating tactics by hiding behind crowds. Dragged us to be participants in this show. It's time for this court to tell me that this show is over. The court must send out a strong message to other the offenders who fire shots amongst crowds and endangering the lives of others, that if you do commit the crime, you will do the time. Counsel refers to the supplementary, it says the repetition.
morning. That Mahmoodiana versus the EFF the speaker for a broad constitutional proposition about value of liberty and the role of the court. I submit that these authorities are entirely inapplicable to the present sentencing inquiry. It's not applicable in use for the death penalty. We are not seeking the death penalty. Its ratio has no application to the imposition of a proportionate custodial sentence for serious firearms offences. It doesn't even relate to firearms. It concerns a constitutional crisis involving Parliament. Observations about the rule of the court as a stabilizing force support the state's position. Court must uphold the rule of law and the principle of equal treatment. Mr. Swartz was sent to prison. Another gentleman I referred to also was sent to prison. How fair will that be? Will that be a consistent, standardized approach? If a non-custodial sentence, what must Mr. Swartz think when he hears or sees that the accused, because of his standing in society, the fact that he's famous, that he did not get a custodial sentence like the ordinary man on the street? It's my submission that will be really a discrimination against the poor in favor of those powerful. So where it affirms the constitutional value of individual liberty, the state does not seek to ignore that value. It submits that liberty, properly understood, must be balanced against the rights of 20,000 persons whose safety was deliberately imperiled, and against the rights of society to equal and consistent application of the criminal law. One thing and then I refer to another thing. That's why I specifically said in my head that it was a double-edged sword, and the court must understand it in that way that 7 years is for an ordinary man. Above 7 years and up, it's because of his position and the precedents that he created by doing such. The case of Pretorius was never charged for being in possession of a firearm. He was charged for discharging a firearm in a restaurant of 200 people. He was charged with unlawful possession of ammunition and not possession of firearm. Displaced because that issue he was imposed that type of sentence for that discharge in the restaurant. If you multiply, I don't know how my accounts are. That was 100 times more. In this case, Pretorius fired, shot accidentally, and he was imposed a suspended sentence. Contrast with the accused who fired, according to him, deliberately so, says he can fire anyway if he deems first. Yet this man was apologetic because he knew he was not supposed to do that. In this case, the accused says, I can do this, and please don't tell me how to do that. Multiply that by 100, then we'll get to 20,000 people. That's how serious this was. Was the Pretorius 200? He accused fired 20,000 people plus, excluding the community around in that side area. So the aggravating factors, just to conclude, the court must consider the degree of premeditation, the lack of remorse, the inadequacy of Ms. Thompson's evidence. She spent 5 hours assessing the accused, and I'm not talking about 5 consecutive hours that you can at least get an idea who the person is she's dealing with. She speaks about an hour and a half here, an hour there, and 2 hours there, on different dates, different times. She was just basically there to do her job, just to compile a report for the purposes of these proceedings, but did not compile it to assist this court to come to the correct decision. She was biased in her assessment. Basically, she was employed by the accused to come and bring that report because she was paid for it. His absence of remorse, insight and accountability, until today he still doesn't see what he did, what danger it posed, and what the consequences could have been. His position as a public leader and a role model to the young and to society. The fact that he's a lawmaker, breaking the law. The fact that 2 firearms were used and live munitions were fired, not once, like in Oslo Pretorius, not twice, but multiple times. The degree of premeditation involved and his deliberate conduct puts him in the category of 7 to 15 years. If the court imposes a custodial sentence, it will satisfy the principles as set out in State versus Z. And the court will do its constitutional mandate of equal treatment before the law, and will serve the legitimate and pressing interest of a society that has the right to expect that its leaders and lawmakers be subjected and to obey the same law that they are elected to uphold. That's my submission, unless there's anything else for one to do.
Thank you, Advocate Caesar. Be with you now. I just want to get the charge sheet and endorse. I'll be with you now, Advocate Nkupa. Thank you.
One more issue.
Just one issue that I the state conceded that it did not prove its case beyond reasonable doubt, that it was unable to show in the video or see the video that it was Mr. Snyman that gave the firearm to Mr. Malema. That part was inconclusive, and that was the reason why Mr. Snyman was acquitted.
And the floor is yours.
I have
Thank
5
you.
points to reply to.
Yes.
The first one is the firearm issue. It is an important issue, although my learned friend tries to make light of it, because it's all regulated by statute. Firstly, your leadership wanted to know what the source of the evidence is. The first part is page 21 of the report by Ms. Thompson at paragraph 50.4, where she says, it appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from the tactical security services, who provided security services at the celebration event. However, no individual was convicted of supplying or transferring the firearm to the accused. And this is the crucial part. And the rifle that was shown in court was returned to tactical security services before judgment was delivered in this trial. That's the first part of the source. Then, if you then go to the transcript of the evidence of Ms. Thompson at page 35, at line 8. She says, however, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to tactical security services before judgment was delivered in this trial. Now, why does this matter? It matters because the forfeiture of firearms that are used in the commission of offences regulated by the Criminal Procedure Act. My learned friend has already referred us to section 30 of the Criminal Procedure Act. But your leadership will discover that section 30 is actually inapplicable in the current circumstances, because it deals with disposal by police officials of articles after seizure. It doesn't deal with articles that are part and parcel of the criminal proceedings themselves. Similarly, section 31, which is another section that was relied upon, refers to disposal of articles where no criminal proceedings are instituted or where the article is not required for criminal proceedings. So we know in relation to the first requirement that criminal proceedings were instituted, and in relation to the second requirement, the firearm was required for criminal proceedings. So it also does not apply. What does apply are the two sections that were not referred to by my learned friend, which is section 34 of the Criminal Procedure Act. That section is headed Disposal of Articles after Commencement of Criminal Proceedings, which is where we are. The criminal proceedings have commenced. The article is a piece of the evidence that could be used to prove the offense. It says the judge or judicial officer presiding at criminal proceedings shall, at the conclusion of such proceedings, but subject to the provisions of this Act or any other law under which any matter shall or may be forfeited, make an order that any article referred to in section 33 be returned to the person from whom it was seized, if such person may lawfully possess such article. So it is up to your leadership to make an order that an item that was part and parcel of the commission of the offense, which was used in the criminal proceedings, may be returned. It's not up to the state.
Why that is important is also Section 35, which is another section that was not relied upon by the state. That deals with the forfeiture. So your leadership will know under Section 34 you may order the item to be returned, but under Section 35 you may order the item forfeited to the state as well. Because under Section 35, subsection 1, it says a court which convicts an accused of any offense may, without notice to any person, declare any person, instrument, or other article by means whereof the offense in question was committed, or which was used in the commission of an offense, or if such conviction is in respect of an offense referred to in Part 1 of Schedule 2, any vehicle, container, or any other article which was used for the purposes of or in connection with the commission of the offense in question, or for the conveyance or removal of the stolen property, and which was seized, and we know this firearm was seized under the provisions of this act, forfeited to the state. So what happened here is that the prosecutors on their own showing agreed with one of the accused persons to take the firearm before judgment was given. That raises profound questions of the propriety of the conduct of the prosecutors. They themselves admit that they sent an email, although they put a different slant to that email. The slant they put is that they said, if you are acquitted, you may come and collect the firearm. Whereas the provision in Section 34 says the judge or the magistrate, whoever is presiding, may make that. And it raises profound questions, my lady, with the greatest of respect. The first is, how does the accused know that he must come and collect the firearm? But it also raises another question, which is, how did the state take this matter as serious if they were already making arrangements prior to judgment upon the return of the firearm? They say that there were emails that were exchanged, but those emails have not been produced. And that is in the context where a witness has given evidence. It is correct, as my learned friend points out, that the witness says, my source of the evidence, you see that in paragraph 5.1 of the report, my source is Mr. Malema. But if they had this email chain, you would expect that on the day the witness gives evidence, they put it to her. But they don't. And then they try to get that evidence introduced in argument, which your leadership can just dismiss without more. So we submit, therefore, your leadership, that there is a potential irregularity which flows from the non-compliance with Section 34 of the Criminal Procedure Act and the non-compliance potentially with Section 35 of the Criminal Procedure Act. But we say it also raises really profound questions about how this knowledge occurred prior to the delivery of the judgment. We leave it there and take it no further, but we say it does raise deeper questions that require interrogation. But it does show that even on the state's showing, they did not regard the offense to be serious. Why do you return the instrument of the commission of the offense prior to the delivery of the judgment? Why? So that's in relation to question 1, which is the return of the firearm. We say it's relevant to sentencing because it shows that the state did not treat this as serious, but it's also relevant to a larger question about the propriety of the conduct of the state. The second question I want to address then is to look closely at why does the state say Mr. Malema should go to jail? This is clearer because the main heads of argument are actually quite confusing about why they say that he should go to jail. It's clarified in the supplementary heads because there they identify 4 reasons, and I want to address each and every one of them now. The first one is this idea of premeditation, that the offense in question was premeditated. But it seems that they actually misread the evidence because the planning that Mr. Malema talks about, if you look at the supplementary heads of argument, the leadership will find this at paragraph 7 of the state's heads of argument. In the italicized portion, which has inverted commas at the bottom of the page, where Mr. Malema is quoted as having said everything was perfect and calculated and designed to be the way it was done. He is not talking about planning the commission of an offense. He's talking about planning the celebration, the celebratory event, even on what they have quoted here. So that's why it's important never to read words out of context. What they have done is that they have planted words in their heads of argument, and then they have imputed a meaning that those words were never designed to achieve. And we say, in addition to the distortion of what the actual evidence was, the evidence was not planning the offense, the evidence was about planning the event. That actually cases of planning and premeditation of a design. How are we going to rob a shop? How are we going to rob a bank? What they don't show is the spontaneity of a firearm being given to a person, one shot, which is on the evidence, and your ladyship, you'll see from our heads of argument. But the second conviction is about one bullet. It's one bullet, not the 22 bullets, one bullet. So ordinary cases of premeditation do not have that element, because what you find is that a group of criminals sit and they plot how to execute an offense. This is not where someone gets a firearm, they shoot, they retain the firearm, and that's the end of the story. So it's even inconsistent with a classic instance of premeditation. And bearing in mind, my lady, that the state says, if you look closely at what they say in paragraph 7, the most significant aggravating feature. In other words, they hinge their case on the premeditation. But if the basis of the premeditation is a misconstrual of the evidence, your ladyship can discard that without more. So that's item 2. So we say your ladyship can safely discard that because they've misconstrued the facts. And in any event, they overlook the fact that we're talking about one bullet. The second reason why they say Mr. Malema should go to prison is because they say it was 2 firearms. But we don't understand. They say 2 firearms, 22 live rounds, and 20,000 people within a community. We don't understand why they say that. If your ladyship goes to our heads of argument, we start off by summarizing what the actual findings were, not what the state wishes the findings were, but what the court said the findings were. And the important ones is 1.2, unlawful possession of ammunition in contravention with Section 90 of the Firearms Control Act, to wit. Now those words, to wit, usually mean in that. In other words, their point is to constrain the factual basis of the finding, not to expand it. A .223 Remington bullet, one bullet, without holding a license, permit, dealer's license, manufacturer's license, gunsmith license, import or export, or in transit license or other authorization. 1.3, unlawful discharge. But that's the unlawful discharge of the one bullet that he was in possession of, referred to in the second conviction. So we have the same problem here, my lady, with the greatest of respect, that the findings are distorted. It's a narrative building. Yes, and my learned friend also points me to even the first finding is unlawful possession of a firearm, not the firearms, a firearm, one firearm, one bullet. So we've got a problem here that when you look at the second reason why they say Mr. Malema should go to prison, there is a disjuncture between what the state says and what the court found. You can't do this. You can't send somebody to prison for reasons that the judge did not find him guilty of. So this is the problem now with item 2 firearms, 22 live rounds before 20,000 people. So in other words, the correct postulation is one bullet in a stadium of 20,000 people. One. That's the correct postulation. And then ask yourself, in those circumstances, should I send this man to prison? And it's so absurd that they say, don't only send him to prison, send him to prison for 15 years. So it's like a game that they're playing. It's a game to inflame the passions of the public. Then the next reason why they say Mr. Malema should go to jail is if you look at their supplementary heads, because he's a public leader and a role model. Now here, my lady, I sympathize with the state that we say, well, people that are holding positions of society should take responsibility and they should be good examples. But it's precisely the same reason that Ms. Thompson says you should look at Mr. Malema differently. And your ladyship, I want to remind your ladyship, when we were here during the evidence of Ms. Thompson, your ladyship commented, and they said, what's so special about him? The state says he's special. When we now say today, treat him through the prism of Section 9, everyone is equal before the law. So in other words, my lady, what we have is that for the state that chops and changes its case, depending on what it wants to achieve at a particular point in time. Today, they are trying to expand the realm of penal activity as expansive as possible. And then they say, okay, look at the fact that he's a parliamentarian. But when the witness was here, they said, no, his parliamentary position is irrelevant. He must be treated like everybody else. But a court cannot follow that unprincipled approach. Your ladyship must apply Section 9 of the Constitution, which says everyone is equal before the law. We obviously take into account that Mr. Malema must bear responsibility as a leader in society. We don't run away from that. But it's precisely because of that factor that we say, if you actually look at the fact that he has been criminally charged, it's a public trial that he's been undergoing. The fact that since the day of the charge, there is not even an allegation that he has ever attempted anything to do with the possession of a firearm. The fact that even before he was charged with these offenses, there is not an inkling that Mr. Malema had a propensity to possess firearms or to discharge them openly and publicly, recklessly, as the state tries to argue today. And the fact that the public trial itself has a shaming effect on the public representative. It has a shaming effect on the public representative because already people are saying, oh, well, why should he not lose his seat in Parliament? Why should he not lose his seat in the JSC? And the fact that, my ladies, the fourth part of it, is that we are not asking for a no punishment. We are simply asking for a non-custodial punishment. And no one can sensibly say that other forms of punishment do not constitute punishment, which is the zero-sum argument posited by the state. There is only one punishment as far as that concerned, it's custodial. So what we say, my ladies, is that you have a range of penal options that would reflect the society's disapproval of, I would say, public misconduct by public representatives. And the custodial penalty, in fact, achieves the opposite. So we say that ultimately it's a neutral fact that he's a public leader and a role model. The next one that they say you should actually send him to prison for is that he has no remorse. But they themselves say in Hewitt versus S, absence of remorse is not an aggravating factor. The state says that in paragraph 17 of their heads of argument. It's not an aggravating factor. But my lady, there is a fundamental legal problem with the argument. If an accused says, after conviction, I disagree with the magistrate, I'm going to appeal because the magistrate has wrongly found me guilty. The state says, infer from that he's not remorseful. It's absurd because even under Section 35 of the Constitution, he has a right to an appeal. And the right to an appeal is based on a view held by an accused, wrongly or what, that the magistrate is wrong. You cannot say, I am going to punish this accused because he articulated a view that I'm wrong. That is just an abuse of judicial authority. So he is entitled to say, I respectfully think that the judge got it wrong, and I'm going to appeal. The judges on appeal may say to him, Mr. Malema, it is you who is wrong, and not the judge. But in expressing the penalty, a judge cannot say, I'm going to punish you more because you've said it's absence of remorse just because you say, I do not agree. And I want to take this point further about the absence of remorse. They say, Mr. Malema has said these proceedings are an abuse of resources and the prosecutors are incompetent. That's what they say in their heads of argument. But my lady, if the prosecutor takes personal an accusation that they are incompetent, you know what happens? they violate Section 179 of the Constitution, which says that they must prosecute without fear, without favor, without prejudice. In other words, they must be prepared to accept the accusations and the criticisms from accused persons. They must not say, this accused person said that we are incompetent and therefore he must be punished more. Because that is not how the law works. The law works on a dispassionate basis. Whether someone has a loud mouth or that doesn't have a loud mouth, they must still be treated in accordance with the law. So we say that there is a deeper problem with this idea that because he said they were incompetent, therefore he must be punished, because it's not retributive, which is fine for sentencing, but it's vindictive, which is in conflict with the Constitution. So we say your leadership cannot give an order that would be in violation of Section 179 of the Constitution. Then they say, this is now paragraph 18, where in B they said, it described the proceedings as an abuse of the NPA resources and an incompetent prosecutor, and that AfriForum was to be blamed. Again, we all know the history of this case, my lady. We don't have to repeat it. It is AfriForum that has been behind the prosecution of Mr. Malema.
On which ones? Supplementary or the first one? 18B.
So there they say, Mr. Malema complains of a political vendetta by AfriForum. That's the point I'm addressing. Leadership doesn't want me to refer to AfriForum, that's fine.
No. Sorry, Advocate Nkukaitobi. I'm just quickly reading what you are referring me to before saying that I don't want you to say it. Let me just read the paragraph quickly. Okay. Advocate Nkukaitobi, I've got that. I hear you. This is what the narrative of your client's evidence was during his evidence in chief and cross-examination, which the state is quoting here, according to my understanding. But you may proceed. I'm noting what you are saying.
It is the state that says that Mr. Malema lacks remorse because he has blamed AfriForum. I'm simply explaining.
And the Holy Spirit, including
I'm not dealing with the Holy Spirit, I'm dealing with AfriForum.
Please leave. I've spoken, so I was very clear that there will be no choice. So I don't know how we are going to approach this. It's distracting to counsel for the accused. It's distracting to the state and to the court. And I do not need your approval of yes and no, because I'm independent. I don't mind yes or no at all. So do you leave or what? Because I'm not going to tolerate it. So there's a whoever wants to comment, please leave. Whoever is commenting now, please leave. And from now on, I will leave that in the hands of SAPS. Whoever comments or speaks, ask them to leave, please, because I'm concentrating on what counsel is saying to court. Sorry for that.
Let me just get one sentence on AfriForum, because I think that's what is increasing the temperature inside.
I'm listening.
Mr. Malema is entitled to regard AfriForum as a political adversary and to criticize it for an unfair prosecution, because he believes that they are behind his prosecution. What you cannot do, you cannot take that political statement by Mr. Malema and take it to account in sentencing.
I hear you fully, yes.
Thank you, ma'am. Then, they are also complaining that he has complained of racism. Why is the state complaining that Mr. Malema is complaining of racism when he's a victim of racism? It makes no sense to me at all.
Okay, I'm not going to respond, but I'm listening, yes.
No, I'm not asking your leadership to respond. It's a rhetorical question. Is why would the NPA complain that Mr. Malema is saying this prosecution is part of a racist campaign against him? Why would they have an issue with that? And why would your leadership be required to put that in your judgment, in sentencing? Now, the last one is the Holy Spirit. Nothing is to be said about that. Then C is showing no insight to the danger of 20,000 people. But if you look at closely, it is precisely the same point as Roman figure 2. Nothing is added by putting it here. Then D. He has sought throughout to conflate the rule of law with political persecution, undermining public confidence in the administration of justice. Now, it's unclear what are the facts on which they rely here. Why do they accuse him of undermining public confidence in the administration of justice? What did he actually do? Because, my lady, people that undermine confidence in the administration of justice, you know what they do? They don't come to court at all. They shout at the court from outside, and then they are ultimately found guilty of contempt of court for not showing up. Mr. Malema has been exemplary throughout the trial. He has been truly exemplary. If he's told come on the 9th to the 20th, he's here on the 9th to the 20th. Come at 8:30, he's here at 8:30. He has never once missed a beat. When he had to give evidence, obviously his personality came through, as you heard from the witness, who said he does have a combative style of speaking. But having a combative style of speaking should not be conflated with disrespect of the judicial process. So we would submit to your leadership that you cannot take this factor into account. There's just no evidence that Mr. Malema ever acted in a manner that shows disrespect to the proper administration of justice. This is particularly so when the prosecutors are not confident enough to pinpoint the specific evidence on which they rely for saying he has undermined the administration of justice. And then, my lady, here's the point I was making earlier, paragraph 19. Critically, the probation officer, Ms. Thompson, herself acknowledged that the accused continues to assert his innocence. So, this is the point, my lady. After conviction, the accused says, I'm innocent. Now the state says, take that into account against the accused. He will say he's innocent until the constitutional court says you are guilty, at which point he will then accept that perhaps I'm the only one who believes I'm innocent and everyone else thinks I'm guilty. But the mere fact that at this stage he is asserting his innocence is not a factor that counts against him. But if you did that, you then violate Section 35 of the Constitution that gives you the right to appeal. The last point, my lady, is to correct some legal misconceptions. Your leadership has been given this case, Janssen versus the state, by Fansei DJP. My lady, this case is unhelpful to you. This case is about someone with previous convictions. It is a case where minimum sentencing legislation applies. And it is a case, if you look at paragraph 2 of the judgment, where it says the appellant produced the firearm, Robbenheimer ran away and he heard the sounds of gunshots. The appellant was known to him as being a member of a gang called the Fat Cats. It's a case of gangsters. It's not a case of a politician in a temporary lapse shoots a firearm to the sky. This is a case of proper gangsters. There is absolutely no basis why the prosecutor says you should read this judgment. It will help you, because it will not help you. Then, my lady, you have a collection of cases. And again, this is another misconception. We've cited, and I will ask your leadership when you retire to have regard to these judgments. In paragraph 31 of our heads of argument, we've done precisely what the state says we didn't do, which is to separate cases of possession from cases of discharge, and to look at the patterns of sentencing for possession versus the patterns of sentencing for discharge. What we find at paragraph 31, and this is all set out very usefully in the judgment of Cluster J, S versus Matikane, where he refers to, I think at that point, all sentences that he was aware of on possession. So, you see, S versus Malema, the sentence that it was an automatic firearm, not semi-automatic, automatic. The sentence was, there was a direct imprisonment. On appeal, it was altered to 2,000 hours of periodic imprisonment. S versus Zondi, where there was a conviction and a direct imprisonment, but converted to a fine of 2,000 rands or 18 months imprisonment. And then the last one that would be relevant for our purposes is S versus Limo, which is the last of those cases. Initially 18 months, and then ultimately converted to 6 months, fully suspended. Those are possession cases, possession. And then we then deal with discharge cases, which we start dealing with at paragraph 35. S versus Fayun, S versus Pistorius, Munsami and Anaga, and the Bada versus S, paragraph 41. Yes, 4 judgments. What the pattern appears to be, my lady, is that almost invariably, in discharge cases where there's no harm, no direct imprisonment is ever ordered. Pure discharge. No direct imprisonment is ever ordered. All of the cases we found. Discharge the firearm in the sky. I mean, Julius' case was actually a paradigmic one because it's actually in an enclosed room. It's like here in the court. The place is full of people, and then Oscar shoots the firearm. It's not his firearm, someone else shoots it to the roof. And then they say 3 years fully suspended. Don't go to prison. So the pattern on discharges where no harm is an issue is non-custodial as a default position. For possession, the pattern is mixed. I accept what my learned friend says, that there are cases we will find of 7 years. But virtually every case we've looked at that they have cited always involves, that this one we've looked at, gangsters or some sort of other offense that is the possession is part and parcel thereof. Not one case involves an instance, which is what we describe as a fleeting possession. Somebody comes in, take this firearm, shoot it inside the car, bring it back to me. Never found a case like that. So it is not correct for my learned friends to ultimately come to the conclusion that the pattern of sentencing in possession cases reflects custodial sentences of between 7 and 15 years. That's just not part and parcel of the law. So, my lady, what you have, you really have a wide canvas. A wide canvas that starts from fully suspended, mixed suspended plus fine, or fines. Then it stretches all the way to 15 years. That's the true state of the law. And we have shown in this case the unique facts that were pleaded by Ms. Thompson. My learned friend can complain about Ms. Thompson's bias, etc., but the fact of the matter is there's only one witness on sentencing, one witness. The state could have controverted that by bringing their own witness. They never did so. So, my lady, we come back then to the beginning. We ask for a non-custodial sentence. But the nature of that non-custodial sentence is in your ladyship discussion. What we simply say is that it will be contrary to the law. Not because we like Mr. Malema or anything. It will be contrary to the law to send him to prison. Thank you very much.
Thank you, Advocate Nkoka Topi. Thank you. There's no provision for you to reply, Advocate Caesar. This is it. The defense, am I going to indulge him? It's not procedure. He's trying, he wants to rise, so you may outvote him.
It's supplementary heads into areas for the argument, and even after his argument, he had an extra point.
Okay, the extra point I disregard, but with the rest, we stick to procedure. Is it a new point?
There's no need to address anything.
What you want is not raise the point, but on what is the basis of you wanting to do so, that I can listen to, and then I can tell you yes or no.
No, you was just going to advise counsel to read section 30 to 34.
No, okay. That is a no. All right. Thank you, Advocate Caesar. All right. So that is us for the day.
But then, since no one is speaking to your leadership when you're asking if that is it. The one thing we agree with the state on is that we need to get finished with this.
Yes.
If your leadership is ready with a judgment this afternoon, we would appreciate it.
Advocate Nkukai Tobi, let me be very clear and maybe indulge not in a because I'm not ready. The aspect of sentence today is it's said loud in court. The impact, the tone is not reflected on paper. It's heard and experienced when you are in court. So the actual sentence, yes, must be determined. Having done the groundwork and the summaries, that has all been done. But to say proceed when I've just heard a whole lot of additional information, I have to structure and...
I have absolutely no problem. Your leadership is adjourning us to a date to be advised.
No, we've got 2 days and I intend to do our utmost to reach our end goal. I just don't want to say and commit after I've explained why, and you all know when you read and when someone says, it's a different, totally different impact when you hear and when you read in your office. It's then you go back, as you say, you retire, not yet though, and you combine the two. So that is what I intend doing this afternoon. So we can, sorry, I see I'm keeping you on your feet, but you are free to take a seat. I can go to the extent of, just so that we don't waste time at 9 a.m., to place the counts and the penalty clauses and the minimum, the formalities on record, because that's not something I have to prepare. It's a fact before all of us, but I need to place it on record. I can do that. Or we can say 9 a.m., but I'm not going to go beyond that. So,
Lady, we are just in your hands.
I think it's inconvenient for everyone for me to come back. I will ask you, and maybe you can, Advocate Otis, Caesar, your client. I'm thinking of all the media stations and such to return for me to read out a formality which is known to all, or come back at 9 a.m. But I intend as I say, not to go beyond and for us to reach our goal as planned.
9 a.m. tomorrow.
Then your word is my command. Agree, Advocate Caesar? All defense? All right. Mr. Malema, just a minute please, gentlemen. The court is not adjourned yet. We are still busy. For the reasons I've mentioned then, and for us to, or for the court to proceed or commence with sentence, and hoping that we will reach the finality of this matter tomorrow for anything that may follow. Tomorrow, I would assume it is the same venue, but I'm also directed by the management. I assume it's the same, 8:30, for us to start at 9 a.m. I'm sure the same venue, which is High Court venue. Okay. Thank you. Court will adjourn.